Good afternoon. We're going to get right started. The Accessible Business Interest Program is a pretty meaty subject, so we're going to make sure we have enough time for you guys to be able to ask questions at the end. So, thank you again for your kind attendance. I know it's warm outside, a little cooler in here. Good place to be. Kevin, Rhea, Tom, Justin. That's Justin, so I even got that name correct. Okay. So we're going to kick off. Tom, lead us down the road.
Okay, I just wanted to thank everybody for coming. So, I'm Tom Fessler, Senior Building Inspector of the Building Department in San Francisco. So, all right, sorry about that. So the program objectives is to create a greater access to goods and services, ensure that we have a usable and safe entrance, try to reduce the liability by eliminating barriers under access, barriers to access under state and federal laws, and try to answer the drive-by lawsuit, try to keep that to a minimum, and help property owners and their tenants better comply with existing construction-related accessibility requirements. One thing that we always have to remember on this program, what it's not for and what it isn't for is to spend money to, ramps to nowhere, doing silly stuff like that. That's not, to put people out of business, to create vacant storefronts, what we just had, okay? What we're looking for is the most accessible entrance possible without, again, going into unreasonable territory. And I'll get into that a little bit later. So this is it applies only to the primary entrance to the property or tenant space. It doesn't have to do with anything beyond the entrance. So the restrooms, path of travel within the building, it's just a path of travel from, if you have parking, and it's a transit stop right in front of the building, that path there, and then the door, the level landings, the various things that we want, the checklist that we're given to. The partnering agencies, the building department is the program administrator. The plan department kind of looks at any changes to the exterior of the building in front of the historic preservation as part of the review. Public Works is people that have anything to do with the public way, so any work that needs to be done on the sidewalk. The Access Appeals Commission reviews technical infeasibilities and unreasonable hardships that are granted by the building department. The Office of Small Business is a resource for trying to find design professionals that you need to get, contractors or tax credit assessor. We'll speak to that later on. And the Mayor's Office on Disability, they have technical expertise in the Americans with Disability Act. Okay. Closer? All right. All right. Well, it's almost in the, maybe I'll sit up closer. Okay. Anyways. Okay, so, oh geez. Back to this other table. Okay, so this is the table in the 1107B. Okay. Jumping around on that. So it's broken into 4 categories. The first category would be it's a compliant entrance, and once a category checklist has been filled out and turned into the department, you can't be more compliant than being compliant, you're done. Category 2, there's no steps, but there could be other issues. Category 3 are entrances with one step, and category 4 is entrances with more than one step. You can see that the submittal category time frames have passed for submitting the category checklist, except for category 4. Okay, so steps of compliance. The first step is to determine which of the 3 forms you need to fill out for DDI. The pre-screening form, or the waiver form, or the category checklist form. I have copies of those at the table over here after the, you can come and pick up a hard copy if you'd like. Obviously, everything's gonna be online also. If your entrance meets the pre-screening or the waiver form, once you turn those in, you're done. You're compliant with the program. The property owner, you don't need a design professional to figure that out. Step 2, if you're not exempt, then you need to get a licensed architect or a CAS to come out and survey the entrance and complete the category checklist compliance form. Step 3, you need to file for building permits if it's required. And step 4 is to obtain the permit and perform the work and do the required inspections. Okay, so in review, I know there's a lot of different forms here. So in review, which form do I need to fill out? Okay. If you fill out the pre-screening form, it means that you're exempt from the program and you're done. The waiver form is attachment 2. It's basically if you performed work in the past that created a compliant entry, or you have a permit that's underway now, once it's completed and it creates a compliant entry, you can use that as a reference saying, I did the work under this previous permit, so you don't have to hire somebody to come out and re-survey the entrance, okay? What it's really going towards are buildings that people haven't done renovations over the past few years that didn't trigger under Chapter 11B, which is a building code that would require an accessible entrance and improvements to the accessibility to the tenant space. So if you go out and you get the CAS survey and it turns out that you're category 1, that means you're fully compliant and you're done. Category 2, 3, and 4 will most likely require building permits. Now, sometimes it can be difficult right now to okay. So sometimes it's difficult to get a surveyor to come out or to have a contractor. So we understand that. So you can file for a one-time 6-month extension without going to the Access Appeals Commission and say, hey, I need even more time. Extensions can only go up to 6 years from the effective date of the ordinance. So you can just fill that out. Anybody can fill that out. You don't need to have a CAS. You just need to have the property owner. So I've submitted my checklist. What do I need to do now? Again, Category 1 buildings, you've complied with the program because it's fully compliant. Category 2 buildings, you can have instances where there's just minor alterations to the door that you would not necessarily need a building permit. that would be, say, you need to change out the hardware, or things like that. You don't need a building permit. I would suggest you have perform the work, and then you can submit another category checklist, compliance form, saying that you're fully compliant. There is a place on the form, the category checklist compliance form, that does state, does this form supersede the previous form that was submitted? Okay, that's the easiest way to do that. Now, a lot of times you're going to find that providing a power door operator is what's going to need to be done, because you don't have your little landing at the door or the poolside clearance. It's a very common thing that we issue, but it does need a permit to be drawn, and you do need drawings to show the location of that, and it needs to go to the planning department for their approval also, because you are potentially altering the entry or the front facade of the building. And then category 3 and 4 buildings, that's where you're going to have a step or multiple steps. That's always going to require a building permit. That's whether you make it, say you alter the entrance and put in a ramp. Obviously you'd need that, or even if you're doing that for a technical infeasibility or an unreasonable hardship, that needs to be documented through a building permit with plans, and it may need to be ratified. If we grant it, may need to be ratified by the Access Appeals Commission. So here's a couple different examples of entrances that have issues. The first one would be the structural technical infeasibility. You can see the column there at the corner store. We can't move the column that is holding up the building, so that would be an example of technical infeasibility. A non-structural technical infeasibility, I'm not crazy about the slide, but say you had a tenant space up above on the second floor, and to alter the building to get a entry, accessible entry, you would be going into another tenant space. That would be kind of a non-structural technical infeasibility. Unreasonable hardship would cost so much to alter that entrance that it just wouldn't be reasonable. And then equivalent facilitation, that would be when you can see they put in power door operators because the landing is probably not completely level, and you don't have the poolside clearance on the door. The building department can issue that. Without it going to Access Appeals Commission, we consider that to be in the code as equivalent facilitation, meaning it's as equivalent to having a compliant door. So I just went through that, pretty much the same thing. So the ordinance does say that either you provide a compliant entrance or you get a determination by the building department that it's either technically infeasible or an unreasonable hardship is present. And you can see that the structural infeasibility of technical, the building department can approve that without going to Access Appeals. But non-structural and unreasonable hardships would need to be, if the building department approves it, it would need to go to the Access Appeals Commission for clarification. And equivalent facilitation, I gave the example of one with the power door operators. There could be other potential equivalent facilitation offered, and that would may need to be approved by the Access Appeals Commission. And then here's just some forms and guidelines. If you go to the department website, sfdbi.org/business entrance, that's one word. There's information sheets, DA 17, which describes this program in depth. DA 2, it has the forms for unreasonable hardship and technical infeasibility. DA 4 and 5 talk about using power door operators as equivalent facilitation. Again, there's the pre-screening form, the waiver form, the category checklist compliance form, and technical specification and guidelines is in the planning department website. Right now I'd like to turn over to planning for their part of the process.
Hello everyone, my name is Justin Greving. I'm a preservation planner with the planning department, so I spend some of my time down at the Planning Information Center dealing with over-the-counter approvals and also looking at business owners that are seeking compliance through the Accessible Building Insurance Program. So the planning department has put together a checklist that I have copies of if you're interested in actually looking through it in more detail, that looks at the sort of specific areas that we're concerned with from the planning department perspective. The planning department did a citywide survey of all the neighborhood commercial retail zones throughout the city to identify what would be considered sort of important storefronts for their architecture or for their history. And so we have a pretty good understanding of where important storefronts are located throughout the city. And so if you are coming to talk to us about a modification that you need to make to a storefront that is not ADA compliant, we can kind of take a look at the storefront with you and walk you through some of the features that we would be concerned with removing or replacing, and we can help you determine a means of achieving an accessible building entrance. So that's just a little bit about the checklist that we've put together. If you haven't filled out the checklist, you can always just come and talk to a preservation planner. We have regular counter hours at 1660 Mission Street. And so we're located on the ground floor, and it's always helpful. Some of the recommendations that we have, if you are seeking compliance through this ordinance, is to document the existing features of the storefront. It's always helpful just to take detailed photographs of, the entrances, the storefront configuration, the windows, if there's any like transoms, or it's also important to look at what the condition is of the sidewalk in front of the storefront. So I'd say that those are sort of the larger recommendations that we have from the planning department, and you can always come in and talk to us with your program, and we can sort of determine what would be a means of achieving equivalent access to the storefront in a way that is going to be sensitive to the character of the building. And obviously I'm here to answer any other questions you might have at the end, and I have cards if you want to get more information about a specific property.
Good afternoon, everybody. Thanks for coming here. Too loud? Not loud enough? Okay. All right. So Kevin Jensen, I'm with the Public Works Department, and my group, the Disability Access Coordinator section, has developed our accessible business entrance standard, and Public Works has adopted an accessible business entrance program standard that's available on our website. If you go to Public Works website and do a search for standard plans and specifications, this will pop up. Got 4 sheets of drawings. They look like this on the cover. It's on the inside, so it gets into our submittal requirements. And if you take nothing away, if you're a building owner or an engineer or architect, we need a plan that looks like this with actual dimensions and spot elevations on it, so we have something that we can start a definitive conversation about what's feasible and what's not. Otherwise, we're just all waving our hands in the air. So if you at least come in with that, we've got a place to start having a real dialogue about what's possible. So now I'll get into a few slides. And also, I have an expanded slideshow. We have a table over here. This has got 16 slides. I think I've only got 4 or 5 here today otherwise. And other handouts as well, including general information about other kinds of permits that we have in our permit center at 1155 Market. So that our ABE standard is essentially it's a marriage of the San Francisco Better Streets Plan with accessibility criteria in federal and state codes and standards. So in the Better Streets Plan, the sidewalk is zoned in certain zones. You'll see them labeled here across the bottom axis. The edge zone, furnishing zone, which is typically where trees and street furniture and so forth go, if it exists. Not all these zones exist in every sidewalk. The pedestrian throughway zone, which is also the accessible route, that's our key obligation as Public Works under Title II of the ADA. It's our overarching obligation is that over time we get an accessible route down the sidewalk. It's in the pedestrian throughway zone. That's our number one task. Secondarily, how to interrupt that and get in landing so that there's an intersecting accessible route into the business. That's where the ABE program comes in, and how we have adopted this standard on how we can allow certain warping and manipulations, and in some cases encroachments into the sidewalk where necessary and were justified in order to achieve accessibility not only in the sidewalk, but in the business. So that illustration here that is shows that that blue line, that's our accessible route, which is the pedestrian throughway zone, and the accessible route into the entrance. And where those two intersect is a level landing. In this case, what Tom alluded to earlier, DA 04, power door operator in lieu of level landing, that's a ramp up to the door. The power door operator is nearby. So there's a level landing that intersects both of those paths of travel that then is the beginning point to get into the business and otherwise back out again. And you've got to deal with things like, in this case, a transformer vault that's into the sidewalk, which is a big planar object that doesn't warp. That's a rigid plane, and so we've got to deal with that. So we've adopted a range of curb heights that we can use to manipulate that to control the cross slopes. Our ABE standard also allows a range of cross slopes in certain zones where necessary in order to achieve the accessible route in the pedestrian throughway zone. So that's what it looks like in the end. Subtle warping, subtle changes in the curb height in some cases, but it gets the job done. And this is a pretty common scenario with the DA04 or DA05 with the power door operator, and it works. Pretty more extreme methods to do it, which the expanded slideshow gets into some examples for category 3 and 4 sort of situations where we have encroaching ramps and stairs sometimes, where the sidewalk would support that kind of encroachment. This is something I want to point out that, oftentimes buildings have been remodeled in the past. They got the level landing at the door, but in the process, they ruined the accessible route down the sidewalk. So that's not category 1, it's category 2. What that really needs is what we just showed. Take the level landing out, move it out into the pedestrian throughway zone, put a power door operator, and between the two there should be a ramp up to the door. So that's the proper fix on the difference in case if you encounter something like that with a tablet in your building. That's my last slide. No, I have one more. The fine print. I'm not going to read that. You can get all that stuff off of here. Thank you.
Right. Okay, so good afternoon, everyone. My name is Ria. I'm with the Office of Small Business. I'm just going to take, I think I have the last couple of slides here. I'm going to take a huge step back and just provide you with a little bit of an overview and sort of how we got here, what the intent of the ordinance was, and talk about some of the resources that are offered at our office, and also what the interagency group with our departments are working on to help compliance. So just to give you some background, the Accessible Business Entrance Program, it was passed in 2016, authored by then Supervisor Katie Tang. She saw a rise in her district, which is the sunset of drive-by lawsuits related to non-compliance with the Americans with Disabilities Act, the ADA. As we know, or as you may not know, the ADA was passed in 1990. It's a sweeping federal rights law that requires places of public accommodation. Basically, all businesses that serve the public, that are public accommodations, are required to provide access to people with disabilities. Regardless of what you may have heard, there's a lot of misconception, mass confusion, sort of misinformation about the ADA when it relates to small businesses in San Francisco. The one thing that's really important to note is there's no such thing as grandfathering. So our city is a city with steep hills, old buildings, tiny doorways, narrow entryways. Just because that's the city that our buildings were built on does not mean we're not required to comply with the ADA. What that means is it just has made it more difficult for businesses and buildings, property owners to comply with existing federal and state existing regulations. So with that being said, and then Supervisor Tang sort of noticing the rise in drive-by lawsuits, and then also in we're seeing businesses and property owners being sued or preyed on at times, but also having difficulty complying with the complexities of the different disability access laws. So that being said, our office wrote a white paper to describe the challenges that businesses have in complying with disabled access laws, and that was sort of the impetus to the Accessible Business Entrance Program. What Tom started with as the overview, this ordinance was intended to help property owners and businesses better comply with existing laws. For the most part, when it comes to the building code and what's enforced, those are already existing codes and laws that were already in place, many of them for almost 20 years. So that being said, that's where we are today, and that's how we've got to the Accessible Business Entrance Program. So with that, our office has been working with the interagency group here to help navigate how to comply. What we haven't talked about yet is the responsibility for compliance and the complexities between the property owner and the tenant. So this ordinance tasks the responsibility to the property owner, the building owner, since that's who the building department recognizes. But what we know when it comes to code compliance or compliance with disability access laws, we often see a pass-through of responsibility from the property owner to the tenant. So what we're seeing out in the community is some property owners are going through these steps, complying, working with the building department, making sure that they're checking off the boxes. And if it involves their tenant, they will inform the tenant that, hey, there's a power door operator that needs to be installed to comply with this ordinance. Nothing you need to do, you're good to go. But we're also seeing a pass down of responsibility from the property owner to the tenant. Typically, that is written in their lease agreement. There could be a provision in there that states all ADA disabled access is responsibility of the tenant. So we're seeing that pass through happen. And our office is here to help support small businesses so that that if there is remediation that needs to be done, if there's a cost that's incurred as part of compliance, we can help navigate through the resources that are offered and provide assistance if and when needed. We have our website. We have long been doing education around ADA compliance and resources that are helpful for property owners and businesses to comply with the ADA and the Accessible Business Entrance Program. A couple of resources that I'll mention. This one here, this is all at the Office of Small Business table. This is a guide to disabled access compliance. It lays out the responsibilities of the property owner and the tenant. Just keep in mind that with the Accessible Business Entrance Program, there is an overlay of state and federal requirements under disabled access laws. So if you are a property owner and you do decide to pass the responsibility down to your tenant, just note that by doing so, you can exercise your right to do that if it is, say, stated in your lease agreement. However, note that by doing so, you're not removing yourself from responsibilities under the ADA. So under the ADA, both the property owner and the tenant are held liable for ADA compliance. That's another misconception that we see is a lot of the times we'll see with those lease agreements, if the provisions are stated in there, the property owner may think that if the tenant is taking care of it, that they won't be sued. That's not the case. So if you have questions on how that may work for your property or your business having to juggle with it, we can help. We have legal services for entrepreneurs that provides free commercial lease review for tenants or property owners that aren't sure whether or not they should comply or they can pass it to their tenant, or if the tenant should, based on the contract, should take the steps that are being required of them. We can help with that. There are also ADA tax credits that are state and federal. These have been in existence for a very long time. I have some handouts on it. Essentially any removal of physical structural barriers that will help a business or property comply with disabled access laws, you can get back in the form of a tax credit or a tax deduction. I don't know the difference between the two of those, but you'd have to talk to your tax accountant on how to get that money back. And then on our website, we have our ADA resources page to help you sort through some of the resources to comply specifically with the ordinance. There are a couple of phases throughout the process if you are going through compliance, where you will have to consult with or hire a design professional to survey your entryway, or let's say you've already surveyed the entryway and the proposed remediation is that you need to install, say, a power door operator. Or hire an architect to do architectural designs to apply for an unreasonable hardship. Our office can help you navigate those resources. We've heard from just throughout the compliance period to date, we've had a rise in calls on I'm having trouble finding a design professional, I've submitted my checklist, where do I go next? In addition to calling the building department, you can also call our office, because we do work with architects and certified access specialists that are specifically based here in San Francisco. And then with that being said, I do want to just quickly touch on tips for selecting a CASP or a licensed design professional. This is a relatively new ordinance, and anytime that you are hiring a professional services individual specifically for code compliance, please make sure that they know, as you're shopping around, that they know you're looking to comply with a specific ordinance. Outright state that you are looking to comply with the Accessible Business Entrance Program. If they are unaware of the ordinance, you might want to move on and maybe find another architect or design professional that is more familiar with the process, because you're going to be paying this person to help you comply, and you want to make sure that they understand the process of filing a building permit, the regulations or the rules around our sidewalks and our historic buildings and our building code. These are very unique and nuanced. This is very unique and nuanced knowledge here in San Francisco, and just making sure that you're working with the right people to bring you into compliance is really important. Okay, and then I'll leave with the last list of resources here. Here are some online resources to help with finding architects, finding certified access specialists, and also an overview of accessibility regulations and requirements. All right, with that, we'll just take questions, or Gary?
Yes, I'd like to have you cue so everyone can hear your question. I think it's tethered, sir.
I can speak.
Okay, speak loud.
Professor, in your second or third slide, there's a diagram about, in yellow, primary entrance. Why, we're supposed to have what that same diagram showed are rear entrance. So, what's the situation if all employees are required to go into the rear entrance, clock in on a time clock, and put on a uniform? Does that rear entrance for employees only also have to be accessible? Is that situated in?
Tom, paraphrase this question for us, please.
The question is if there's multiple entrances to a building, and say one of the entrances is just for the employees and the other entrance is for the general public, does which do they have to make both entrances comply with the ordinance? I would say that the ordinance is written that it's the primary entrance, so I would say it would be the entrance that the public is going into. You are required, again, under the building code, all the entrances should be accessible, okay? So, but this ordinance is really oriented just to the primary entrance to the building. Now, you could have a building, say, if you go downtown, you have a lobby going into the building, okay? That's the primary entrance going into that building. Now, you could have a sandwich shop that is, you can come directly from the sidewalk into the sandwich shop. That would be another primary entrance. That would just be for the sandwich shop, okay? Let's say you have the lobby, you go in, there's the primary entrance, and the only way to get to the sandwich shop is through that primary entrance. It would only be the primary entrance going into the main lobby. Okay. Yes.
So if you did have two main entrances that are open to the public, both of those have to be compliant?
Yes, I would say yes.
Or more than two or multiple entrances?
Well, yes, because again, if you think of, say, the Westfield Center, okay, they have multiple entrances. There's entrance on Full Street, there's numerous entrances on Market Street. So each one of those I would consider to be a primary entrance going into the Westfield Center.
And then there's also yet on one of the slides from a parking lot, there's a private parking garage, say like underneath. Is that still applicable? Do you have to comply in that instance, or because it is a private parking lot, you don't have to be compliant?
If the parking is supporting the entrance to the business, then the parking will be part of the travel to the entrance. It would be defined as the definition in the building code of the entrance is kind of expanded to if you're coming, where you would come from the public way into the entrance, a landing around the door hardware. If you go to the category checklist, there's 30 different items that potentially could be part of your entrance.
It's the approach walk, the landings at the door itself, the door hardware, entrance.
I have two questions. What are the fines for not meeting the deadline? And how has category 3 and 4 been working through the accessibility board for hardship and feasibility?
Okay, so the first question, the ordinance does, if you read the ordinance, there is not a fine. There isn't a fee schedule or fine schedule in the ordinance. Okay, so if you don't meet the times, the department could write a notice of violation saying you're not compliant with the ordinance, and we would give you a certain amount of time to comply with it. If you don't comply again, then it could go to the second notice, and then it could go to the director's hearing, and potentially we could put an order of abatement on the building, and then start the 50, there's a fee for us monitoring the notice, okay? The ordinance isn't oriented, again, the ordinance is for trying to make it more accessible, let people know, their responsibilities under the building code and the ADA. It's not to fine people.
Public Works standpoint, we're currently working on a number of category 3, 4, and 4 conditions where we are about to approve or we have approved encroachments into the sidewalk that incorporate an exterior landing and ramp and stair and railing where the sidewalk is wide enough and we can support that kind of an encroachment. We usually are working our way through the permit process currently or have already been built already.
And when it comes to Access Appeals Commission, we haven't had too many appeals yet under this program. I think we're up to 3, but it should be more. I think people are kind of holding back a bit to see what happens. The commission has regularly scheduled meetings on the 2nd and 4th Wednesday of the month. Okay, so we have had, and I'm assuming because of the deadlines that we have for the category 2 and 3, it's going to be it should pick up significantly because that's where we're going to find a lot of the unreasonable hardships.
I want to chime in on the unreasonable hardship. So, the question there is that our office has been weighing in on with the building department and mayor's office on disability is to help advise or recommend to the Access Appeals Commission how to or what criteria to look at when assessing an unreasonable hardship. So basically an unreasonable hardship is, let's say we have a property that has 6 steps to the entry, or let's make it easier. Let's say 2 steps to the entryway, 1 step to the entryway. The conditions there that the Access Appeals Commission has to essentially ratify is whether or not that will be approved or not. If that person requesting the unreasonable hardship has grounds to be able to do that. Our recommendation and what we're sort of trying to portray is, while it's difficult to put parameters around what's challenging or what's financially unreasonable, is going to be between one who's requesting it. So, for instance, another intent of this ordinance is because the ADA has been in law for over 20 years now, what we're seeing is just sort of kicking down the can. We have owned this property for a very long time. We know that there's the ADA. Nothing has still been done to provide access, which is the first order of priority under the ADA, is just to provide entrance through the door. There are other elements to it, but that's essentially what this ordinance does. If you're a property owner requesting for an unreasonable hardship versus a tenant requesting for an unreasonable hardship, there will be, those 2 scenarios will be weighed differently because one, the property owner you can argue that there's value in a San Francisco property. If you own a property, there's some value there. While it can be unreasonable, say it will be thousands of dollars to repair it, if you are looking at a high rise and there's that question of an inability to afford it, that will be weighed differently than a tenant who is required to comply, who is on a month-to-month lease, has no idea if they're going to even going to be in that space a month later, but they're having to comply with this ordinance. Those are sort of the things that we're thinking about with advising the Access Appeals Commission. We know that there will likely, or we anticipate that there will be, with those multiple steps to the entryway, we'll see some complexities in that. But with that being said, also, this is also a work in progress for the unit here. And there's a lot to work through, and this is sort of a new endeavor for all of us. But we're sort of working towards being able to address some of those issues.
I could add to that. Essentially, there's two main paths where access area removal is going to happen. One is as part of what is readily achievable barrier removal under the ADA, or otherwise access barrier removal projects only under the state and San Francisco Building Code. Those are voluntary accessibility upgrades. They're not part of an alteration of the project. You're just doing barrier removal of existing barriers to accessibility. What is readily achievable is something that the building owner has to be able to defend in court when they're sued over lack of access, or someone claims there's a lack of access. So that never goes away. If you're claiming that you can only do so much because that's what is readily achievable for you as a building owner or business owner, be prepared to defend it and have the evidence of why you made that decision. Cost estimates, designs, what was considered to be feasible or infeasible at the time, technically, and what those costs were, and what you can afford in year one and versus year 20 when you're saving your pennies to build something over time, right? That obligation never goes away. If you have an alteration, state building code, San Francisco Building Code, you look at the valuation of the alterations over the past 3 years, you add those up. And there's threshold criteria, and there's a certain percentage that you have to expend with a hierarchy of barriers that you have to remove, beginning with the entrance, which includes the sidewalk, the approach walk, the landing, and the door. That's the first place you spend money, before the bathroom, before the drinking fountain, the entrance. And then on from there. And if you do all those things correctly, if your design professionals do that correctly, you have the evidence to defend yourself when you do get sued.
Hi there. Tom, kind of going back to one of your first slides with the that kind of yellow path, and it showed it starting at a bus stop there.
Right.
So if a property owner has a bus stop in front of their building, are they responsible for making the paving at the bus stop compliant, or is this a muni requirement?
I'll let Kevin, because that's out in that's a public way. So he says if the entrance that's the subject of the ABE action happens to be co-located with a bus stop, we look at the sidewalk typically from the flow line of the gutter and the curb all the way to the building face. And so if we have to get into modifying and warping the sidewalk at an entrance that also happens to overlap with a bus stop, we have to take all that into consideration. That said, my expanded slideshow gets into this a little bit. You don't have a furnishing zone, you don't have a curb zone, you just have a sidewalk in those cases. And so in those sort of situations, if the best we can do is a 4% cross-slope across the entire sidewalk from the entrance to the curb, that's what we'll do, because we can't put excessive cross-slope right at the boarding and the lighting area at the bus stop. If you follow me.
Okay, but let's back up there. You were assuming that we have to do sidewalk work. If everything else is compliant, but the bus stop is not, is the building owner required to look at the bus stop?
If the cross slope in the sidewalk exceeds 2%, 2.08%, the answer is potentially yes.
Okay, but very often that part is a furnishing zone.
Well, there is no furnishing zone in a bus stop, typically.
So if there's a bus stop there and you have more than 2%, you're going to be,
It may be that the best we can do is just a single plane from the top up. Maybe we can raise the curb height up and then do less slope across the sidewalk, but that might be the best outcome for all parties, the entrance to this building as well as to the bus stop, but it's case by case. If we can develop and justify a building frontage zone, or we can do something else, we'll do that as well. But the boarding and lighting area has to be more planar than we can justify it, as if we had tree wells and furnishings over to scrub off some cross-sectional height and put in some extra crosswalk in there. Can't do that on a bus stop.
Okay, so just a little deeper on that. We have a bus key, we have a bus shelter. That's our stop. That's the area, or we have a pole that's got a number on it. That's where we're going to put our landing.
We can have the bus stop taken away by Clear Channel. They're the ones who have the contract with MTA, and then reset it after the sidewalk is reconfigured.
Okay, but it's one landing at that location.
It may be a landing, it may not be a landing, but well, if it all works out, we get a landing either at the door or set away from the door where the path coming out the door and the pedestrian throughway zone intersect, and the power operator accessible from that point.
Okay, so my point is that a bus stop could be 40 or 80 feet long, and we're not required to do the entire length of 40 feet.
You'll be looking at the portion of the sidewalk that's contiguous with the building that you're in. So if it's a corner building, it might be all the way down to the corner. If it's a big block, it's the frontage of that building. Oftentimes, if the cross slope of the sidewalk is non-compliant at the projected property lines, we'll have to try to make those compliant so the work might go beyond 1 to 3 flags on one side or the other to blend that out. So we're not perpetuating an inaccessible cross slope at the projected property line for all time.
My question's for DPW. My building is located on what's called an unaccepted street, and there is no sidewalk whatsoever. The street has no curb and no gutter, and it is unpaved. And so what are my responsibilities for a path of travel in that situation?
Do you have a place of public accommodation in the building?
Well, yes, I think so.
There's no requirement to construct a sidewalk in the ADA. Where you do construct one, it has to be accessible.
Okay. So the current situation of a dirt path is acceptable?
Well, I wouldn't say that. You have an obligation to provide accessibility to the place of public accommodation. That might be a parking place with a passenger loading aisle, and from there, an accessible route into the building.
Well, there is a ramp and a deck, so, but from the public right-of-way, the public right-of-way is completely non-compliant, but everything on my property is in fact compliant.
In that case, in those unaccepted streets, the property owner is responsible to the center line of the street. So the property owner has a responsibility and the ability to provide an accessible parking space, potentially, and a landing, and from there, an accessible route up to the door that's made accessible.
But that contradicts what you said earlier, that I don't have a responsibility to pave the street.
You have a responsibility to provide accessibility. There's not a requirement in the ADA or the building code that you provide a sidewalk, but you do have an obligation to provide accessibility.
Excuse me, we're running late short on time, so I think we can do this off to the side. We can do it. There's one person that's been waiting. Hopefully it's a quick question.
It actually is. I have
Okay,
just
good.
two very quick, really quick questions. First is just the category 1 through 4. Is how would a building owner determine whether they're in category 1, 2, 3?
Okay, that's when you need to hire a certified access specialist or
Okay.
design professional to come out and survey the property.
I see.
What you can do as a property owner is you can, determine whether you're not a place of public accommodation, okay? And you can fill out the pre-screening form saying, hey, I'm not a place of public accommodation, I'm exempt from the program. Or you can fill out the waiver form saying, hey, I did the tenant improvement, we did the entrance 2 years ago, here's the permit number, it's been completed. We can look it up in the computer, we can see that you've done it, check it on Google Maps, and then you're done.
Okay, perfect. I just wanted to make sure it wasn't something that just.
Now,
came up with.
once you're filling out the checklist, it's become too technical for the layperson, so you do need to hire somebody.
Got it.
And those recommendations need to be followed up by most likely a building permit, especially if it's a category 3 or 4.
Okay, and then just like a really quick question. If you comply with this ordinance, that does mean that you comply with the ADA in terms of the entrance? No?
No, that's, okay, so that's one of the things, you can comply with this ordinance because it was based on, some of the requirements on this ordinance were based on the 1998 building code, okay? So you can be compliant with the ordinance and still not be in compliance with the ADA or the present California code.
I see. So even if you comply with this just for that one public building entrance, you still might not be in compliance with the ADA.
Correct.
Thank you.
Thanks, guys, for some really great and insightful questions. The DVI raffle, but I want to introduce to you the person who runs the city on a day-to-day basis, City Administrator Naomi Kelly.
Thank you. So I'm going to get straight to the point because I know you've all been waiting for this minute. I've got raffle tickets here that were picked out earlier, and now I'm going to announce the last 3 numbers for 10 people. So, yes.
Where do we get those? I signed in on one event, right? Nobody said anything about tickets.
All right, so someone from DVI helped this gentleman out. he did not get tickets. Okay, so number 466.
466.
Okay. Number 455. I think we have someone right there. All right. Number 398. 398. Nope. Okay. Number 430. And if you have numbers, stand up. Nope, that's a stretch. Okay. Number 430. All right. Number 458. No. Number 468. We got a winner here. All right. And it's earthquake safety preparedness bag. Someone's going to come by and, there you go, right over there. Number 489. All right. There's another earthquake safety emergency bag there for you. Number 441. Number 459. And the last one I have here is 418. All right, we have another one right there. All right, well, thank you all. I know this has been a long presentation, and thank you for taking your time out to come to the Earthquake Safety Fair.